Hello, everyone. I thought I would do a quick discussion of federal courts first, and then slip into some other issues that peripherally deal with preliminary objections. So, first of all this talk about federal court. Why do people say federal court? Why not state court all the time? Or why not all federal court? Well, let me say this. Federal court is generally a nicer environment. By nicer environment, I mean those courts are not as crowded. They don't handle small claims. They don't handle any matters having to do with family, so they don't deal with child support. They don't deal with custody. They generally do not deal with divorce. They don't deal with landlord-tenant. So what that suggests is that the federal courts probably don't have as many things to do as the state courts do, and they tend to have more resources. If you can, in my experience, most people want to get to federal court. And to get to federal court, the reason that they have more resources and they're not overwhelmed is that not everybody can get there. You have to have subject matter jurisdiction in the federal court, and that subject matter jurisdiction means that you have to have a claim that has diversity of citizenship and a claim of more than $75,000, or a constitutional claim or a claim under a federal statute. Now, what that means with respect to diversity. Plaintiff needs to be from a different state than the defendant, and there needs to be a claim in the amount of more than $75,000. Plaintiff in Pennsylvania, defendant in New Jersey, claim of $75,000, you're good to go. If both of those people live in New Jersey or both live in Pennsylvania, you cannot go to the federal courts. So that's the first prong of subject matter jurisdiction in the federal courts. If you don't have diversity, perhaps you have a constitutional claim or a claim under a federal statute. For instance, if we all wanted to speak at the college on an issue of importance to us and the college would not permit it, we could probably file an action in the federal court for the violation of our civil rights, specifically our First Amendment rights. Otherwise, there are federal statutes that give jurisdiction to the federal courts over matters that come up dealing with federal agencies. For instance, bankruptcy. For instance, the Atomic Energy Commission, anything to do with atomic energy. Issues dealing with the military service. Any of those cases are required to go to federal court because the federal statutes exist that say if you have a case like that, it has to be there. So those are the two ways that you can get to federal court. With respect to the matter of Pennsylvania, in Pennsylvania, you'd only need instances or a dispute to have happened within the geographic locale of Pennsylvania, and under that circumstance, you could bring an action anywhere within the Commonwealth of Pennsylvania, within the Court of Common Pleas. Now, you have to get to the right court. In other words, if we're in Philadelphia County, but everything happened in Erie County, if we filed in Philadelphia, what happens when you have bad venue is it would get transferred there. Venue is the place or the location of the action. But in any event, Pennsylvania's court of general jurisdiction, its trial court of general jurisdiction, are the courts of common pleas or their subdivisions, and that would be the minor courts, the magistrates, districts, or the municipal courts that exist. So the issue of jurisdiction for state courts is a little bit easier than it is for the federal courts. Now, moving on to personal jurisdiction. Whether you're in the courts of Pennsylvania or in the federal courts, you have to have personal jurisdiction over a defendant for a court to hear the case. And it's considered to be due process. It's a fundamental constitutional right that if you were to be sued in the state of Oregon, and you've never been to Oregon, never did anything to anybody that has anything to do with Oregon, it would be a violation of your due process rights to attempt to bring you there to answer. You don't have a minimal contact with the state. So if you don't have a minimum contact, they cannot assert jurisdiction over you. If you don't have personal jurisdiction, in other words, if the people were never there or had some involvement in the state, you cannot sue them there. Venue is the location where the suit is filed. The difference between venue and jurisdiction is as follows. Jurisdiction is the power of a court to deal with your case. If you don't have jurisdiction, the only thing a court can do is dismiss your case. If you are in a venue that has jurisdiction, but it's the wrong venue, by that I mean, as I said before, file it in Philadelphia County, but everything happened in Erie, then instead of being dismissed, it would be transferred. It would be sent there. And the same is true with the federal courts. If you have federal jurisdiction over a matter and you file it in the Pennsylvania federal court, if the Pennsylvania federal court determines that the proper place to hear the case would be in Ohio, then they can transfer it to a federal court in Ohio, as long as they have jurisdiction. You can also challenge service of process by using a preliminary objection. Service of process is how you are told about the litigation. Most commonly, there's what we call personal service. That is, the documents of the case are served upon you. That's the most common way, and we'll deal with some other ways in which people are served with process. But if people don't serve it upon you properly, in other words, if somebody just puts it in the mail, not certified or any of that, that's probably not proper service. So you could challenge that with a preliminary objection. So I just wanted to give you that brief introduction to jurisdiction, to personal jurisdiction, to venue, and to service of process. All right, thanks for listening, everybody.